Good afternoon. I want to start the meeting with a few expectations regarding meeting guidelines and overarching comments on the bills. I want to start the meeting with a reminder to the audience that we will have time for public comment. I expect audience members to provide their comments at that time. Committee members will be able to ask questions of staff on each bill. If there are any deviations from this procedure, I will ask for order, and then we will proceed. First, we will take up Senate Bill 6011, the bill that I introduced today. I will reiterate my previous comments that I support veterans and their families, and I have spent a lot of time, a lot of hours listening to suggestions on the tuition waiver concerns. Based on that, Senate Bill 6011 includes a full repeal of the VIMS deaf budget language. Shall I repeat? Based on that, Senate Bill 6011 includes a full repeal of the VIM deaf language, appropriations, and additional $45 million for a total of $85 million over the biennium to support the waiver cost. In addition, the bill adds satisfactory academic requirements for VIMS deaf effective July 1, 2025, unless legislation during the 2025 session establishes different standards. Satisfactory academic progress is not a burden since all other state financial aid programs have a similar requirement. Next, we will take up Senate Bill 6009, my bill, and House Bill 6003, patroned by Chairman Turian. I expect that we will pass both of these bills as they will be out of, I expect that we will pass by both of these bills as they will be out of order. This morning, the governor came over to my office to discuss an approach forward. I thought we made reasonable progress, and that is why I introduced Senate Bill 6011. It is my hope that the governor and the House will join me in announcing that we have an agreement. And at this point, I'd like to turn it over to staff to go over Senate Bill 6011.
Madam Chair, I think we may also want to call the roll at this time as well.
Madam Chair, would you please call the roll?
You have a quorum, Madam Chair.
Thank you. And now we'll turn it over to staff for presentation.
Thank you, Madam Chair. As requested, I'm going to describe what's in Senate Bill 6011, patroned by you, Madam Chair. First and foremost, it repeals the language that went into effect today, July 1, from Chapter 2 from the regular session related to the tuition waivers. In addition, and similar to your Bill 6009,
Madam Chair, can I ask April a question?
Senator Obenshain?
Sorry. April, can you tell us where these things are in the bill as you go through? It would be helpful to me. I'm sorry. Sorry for interrupting so early.
That's our, Madam Chair, Senator Obenshain. If you look for where that is being repealed, it looks like it starts on line 178 through 203. You're welcome. So that's the first thing, is it repeals the previous language that was adopted in Chapter 2. The $45 million that was also included in Senate Bill 6001, that would be an additional appropriation from a surplus, an anticipated surplus in the fiscal year end that closed yesterday. It is, it looks like on lines 19 through 28. And that was confirmed by the governor's office this morning that that will in fact be there. Additionally, the bill has requirements regarding academic progress. As Madam Chair mentioned, those are on lines 219 through 231. As mentioned, that is a delay of a year. It is also has a requirement that it might be informed differently by both the task force, the Senate work group, and the coming JLARC study. The JLARC study, also in Madam Chair's other bill, Senate Bill 6009, is also here, starting on lines 232 through 240. And then the effective date is there at the end on lines 241 through 243. The bill, if passed, would make those provisions that impact the tuition waivers retroactive. And Madam Chair, that completes the presentation on the bill.
Madam Chair.
Senator Searle.
Thank you, Madam Chair. I have a series of questions for staff.
Yes, Senator Searle.
Okay, thank you. April, can you ask me a couple questions? Madam Chair, could I have permission to just ask her a series of questions? Siri Adam, instead of going back to you every time? Is that okay?
Senator Searle.
Great. It's just like I'm in court. So, April, can you confirm, does this bill, as proposed, Senate Bill 6011, contain a full repeal of the changes that were made in the budget?
Madam Chair, Senator Serville, it fully repeals that language, as I mentioned.
Okay, does it also require anybody to apply through the FAFSA process?
Madam Chair, Senator Serville, no, it does not.
Does it also require anybody to get apply for Pell Grants?
Madam Chair, Senator Serville, no, it does not.
Does it have any restrictions on whether anybody has to be only in-state? In other words, does it prohibit out-of-state people from participating in the program?
Madam Chair, Senator Serville, no, it does not.
Does it have any restrictions on whether or not people can use the program to go to graduate school?
Madam Chair, Senator Serville, no, it does not.
April, can you also explain to us, does this have any kind of overall cap on benefits, any kind of restriction on the amount of total money that can go out as compared with the current plan? What existed before July 1?
Madam Chair, Senator Serville, no, it does not.
April, one last question regarding this specific bill. Does this bill contain any kind of means testing? In other words, does the net worth or the income of the applicant's parents play any role whatsoever in terms of how much benefits they get?
Madam Chair, Senator Serville, no, it does not.
Okay, thank you. Those are my questions, Madam Chair.
Thank you, Senator Searle. I think before we come to the committee members, we're going to provide for public comment. There will be 10 minutes each side. And so if you already signed up, your name will be called and you can come forward and state your name and give us your presentation. And I want to also make sure you understand that 10 minutes means that everybody is restricted to the 10 minutes one side or the other. Everybody doesn't get 10 minutes. First name?
I think you want people to line up.
Yes, I want people to line up the way they signed up. It's going to be 10 minutes. So just as I normally do with Senate Finance Committee meetings, it'll be 10 minutes total each side. And it looks like the first name is, can you recognize that signature for me?
Madam Chair, I believe it may say Mitch Rubenstein.
Okay.
You want to start?
Yes, timer.
Okay, no.
Thank you.
Good afternoon.
Good
Thank you,
afternoon.
Madam Chair. My name is Mitch Rubenstein, and I am the new State Commander of the Veterans of Foreign Wars Department of Virginia. The VFW has 126 Virginia posts and 35,000 members and auxiliary. Many VFW members are combat veterans. I'm here today to ask that you pass the House Bill 6003, which passed the House of Delegates 92-0 last week. HB 6003 restores the Virginia Military Survivors and Dependents Education Program, which was cut in May 2024, the budget bill. This program provides critical assistance to families of military members killed or disabled. This important program allows military families to receive benefits that their loved ones can no longer provide for them. For many, this program is a path forward during grief or following a devastating injury. As you know, Virginia has one of the largest populations of active duty military, veterans, and military and first responders in this country. Promises to our military and first responders must and should be kept. Promises made to our military, I hope that the committee will pass the bill 6003 in order to keep Virginia the best state in the nation for veterans. My thanks to you, Madam Chair, to all the members of the Senate for your hard work on behalf of the Commonwealth of Virginia. Thank you.
Hello, my name is Lauren Fenty. When I was 28 days old, my father was killed in Afghanistan. Growing up without a father was, and still is, a struggle. Each day, I face challenges and inequities that my friends could never imagine. While there is no upside to losing a parent, there are programs and experiences that can help aid and honor that loss. For me and other Gold Star and severely disabled veteran families, that gap was eased by the VEMSTEP in-state college tuition waiver. Now, with the rollback of that waiver, I, along with many others, feel that yet another thing has been ripped out from under our feet, just as the lives and vitality of our parents have been. In my life, the repeal of VEMSTEP has not only sent a stroke of fear through my family, but has also diminished and nearly stolen all sense of happiness in my last month of high school and the months leading up to my first year of college at the University of Virginia. While my friends were getting ready for prom, planning graduation parties, and enjoying their last months at home, I was and still am scared for the future of my academic and professional success, and spend my days listening to and testifying on the rollback of VEMSTEP. During my high school years, I worked hard to receive over a 4.4 GPA, volunteered over 1,500 hours, joined countless clubs and honor societies, worked a steady job, stepped up as a class officer, participated on multiple club and varsity sports, and spent each day bettering myself to prepare for my future, all while helping my mother in the absence of my father. All that being said, I was ready and excited to attend a top university. However, based on the VEMSTEP tuition waiver, I chose to stay in-state and attend UVA. While I'm extremely excited to attend UVA in the fall, I wonder why I limited myself to staying in-state, as I now see that VEMSTEP has been rolled back. Now, my mother and I are struggling to figure out a plan to keep our financial commitment to UVA, even though the state has revoked their commitment to our family and others. As a young woman getting ready to further my academic career, I'm floored and disgusted that men and women who have been the victims of sexual abuse and harassment, both in and out of combat zones, could possibly be left out of VEMSTEP, and demand that they and other non-combat wounded veterans be included, as well as those who suffer from PTSD. Have we not evolved further than that? It is imperative that this program be reinstated by repealing the language in HB/SB 6001 and restoring it to its full capacity. For the sake of the Commonwealth and its massive support of and by Gold Star and veteran families, I implore you to be a change maker and return VEMSTEP to the state of Virginia and be a hero to our heroes. Please pass 6003 for the land of the free. Thank you.
And the next person signed up, SAR, I guess it's FI?
We're going to change the order, if that's
Beg-
They want to change the order.
You want to change the order?
My child is going to yield to Mr. Freddie.
That's fine. So, she's got it. You may proceed.
Good afternoon, Madam Chair and fellow senators. Before I even start, I would like to personally tell you, Senator Lucas, how appalled that I am of what occurred Friday on the floor. I understand that there are varying positions, but at the end of the day, we always have to come back to decorum and respect, and that respect is earned. So I apologize to you for what occurred on Friday, Madam Chair.
Thank you.
My name is Freddie Harden. I'm a retired Air Force combat veteran, and I want to thank you all for the opportunity to speak before you today. Under the current dire circumstances, I find it necessary to offer a brief lesson, refresher, if you will, in civics. I'll try to keep this very simple. I'll keep it to the 3 Ps. The primary issue before us today comes down to 3 things: promises, procedures, and principles. You failed to keep your promises. You failed to follow proper procedures. And a few of you insist on putting partisan politics before core principles. Virginia is under attack. Our most fundamental, inalienable right, our civil liberties, are being systematically demanded before our own eyes by this very legislative body. If Virginia can rip longstanding public benefits from the families of fallen veterans and first responders and do it in secrecy without any proper public notice, without any opportunity for public comment, without any study, and apparently without any legal review, what else and will be stripped away? We continue to hear things like unsustainable cost, unfunded mandates, sustainability, and other such things to try and justify the harmful wrongs. These are smokescreens intent on distracting and or hiding the much larger issue at hand. The larger issue is how, in the great state of Virginia, can we allow a legislative loophole to exist that enable legislators to regularly and routinely sneak in whatever controversial cuts, changes, regulations, and or mandates they want without informing the public in advance, without any opportunity to be heard, and without the consent of the governed? I'm referring to this disgusting counter-constitutional disruptive process of legislating through the budget. I want to remind you all, the Virginia Constitution mandates that all elected officials swear an oath to support the Constitution of the United States and the Constitution of the Commonwealth of Virginia and faithfully and improperly discharge all the duties. Maybe you all have forgotten what's contained in the Virginia Bill of Rights. I'll close by giving you one excerpt from the Constitution. I really need to give all three, but I'm aware of time. No person shall be deprived of his life, liberty, and property without due process of law, that the General Assembly shall not pass any law impairing the obligation of contracts. Perhaps this applies to compacts, shall pass no law whereby private property, the right to which is fundamental, shall be damaged or taken. Section 15, no free government nor the blessed of liberty can be preserved to any people without the frequent recurrence of fundamental principles. And that such rights cannot be enjoyed safe in a society where law is respected and due process is observed. We, the people of Virginia, demand that you keep your promises, commit to the following proper procedures, and do not let partisan politics override core constitutional principles. Thank you.
Seconds left.
Your name, sir?
Chuck Zingler. I'm the commissioner of our Department of Veteran Services.
We know that, but I just want to make sure that got on the record.
Okay, thank you.
Thank you.
And I want to thank this body for supporting programs that honored our lost, our killed in action, our war orphans with benefits on education programs like this for over 90 years. And when I asked the VA if they ever found a precedent where they were decremented, they could not come up with a single incident where we were returning or denying the promise we made to those war orphans. Americans have been at war for a quarter of a century since 9/11. And I appreciate you giving me the opportunity to lead and represent a community of veterans, of service members, of spouses, of dependents, of survivors like are behind me and have talked to this body beginning at the 13th of this month when we started this task force and even your work group that you've asked for. It is deeply a privilege. Our nation's been at war for a quarter of a century, but really the people that have fought those wars
I'm sorry.
and
I'm
have
gonna
sacrificed from those wars are here. They're represented here and have spoken to you this day. Do the right thing. I've been in front of great organizations. Colin Powell told me that great leaders require to be led as well. All of you at this panel and this body
Madam Chair, I
are
got a question for
leaders.
this witness.
Lead leaders.
Madam Chair?
Do the right
Senator
thing
Servo.
today.
Sir, I have a question for you.
Yes, sir.
There's been a lot of uncertainty right now about the program, and a lot of people have been asking questions about whether it applies to kids who are waitlisted or whether or not if they apply to college later. A lot of questions that could have been answered by Chev to give them the answers to their question instead of all the uncertainty. Why has the administration waited to put out any guidance so that people could have clarity about what the answers are?
Senator, I appreciate that question. There's been so much misinformation, including by Chev. We administer the validation of candidates to this program. No one at Chev has talked about where the prices and where the cost rises has come. It's not just from the individuals. These programs have recognized...
Madam Chair, I have a question for the
Senator Servo.
So my question, sir, is not what Chev's told you and hadn't told you. Why have you not got the guidance out yet?
I've been speaking about this program since the day I came, the 3rd of January. It's the first program that when I was told to come here and recognize those and keep Virginians
Madam
here.
Chairman, thank you for the question. I'd like to recognize you're not answering my question. My question is why the administration has not put out the guidance. I know you've talked a lot,
Come back to the mic so
but
we
why
can
have you
all
not put
hear
out the guidance?
I'm the commissioner of the Department of Veteran Services. I'm not the legislative body. I'm not the executive body. I represent veterans and their family members. So, sir, I appreciate your question. What I was told is always tell the truth, and when you don't know the truth, say, I'll find out. But you might want to ask that question somewhere else,
Thank
sir,
you, Madam Chair.
respectfully. So, if great leaders...
Can you wrap it up, sir?
Yeah, I will, please.
Thank you.
Thank you, ma'am. My ask for you is to do the right thing today. Recognize these families that have sacrificed every day, overcoming the loss of a spouse, the loss of a father, the loss of a mother. Doing the right thing is hard, but when a group of leaders represents this to the leader, it's so much better than the fallow words that say, I support and I care for veterans more than anybody else.
Senator Creedy.
Matt, sir, did you, I understand that Senate Bill 611 was just popped on you before, right when we began, but did you listen to what was said when that bill was presented?
I have not seen the words of six.
Did you hear that the language, all the language that's in this controversy is being repealed? You're getting everything you want plus $45 million.
I'd like to see that, Senator.
For a total of $85 million.
It's right here.
I'll make sure I read it thoroughly.
It's what April described when we started the meeting.
Academic progress is included in the rules at every university already.
Madam Chair.
If you give me time, Senator, I'll read it and I'll respond to you. Thank you.
Senator Favola, and then Senator Locke.
I will just say, Madam Chair, that the issue of the lack of coordination between the Department of Veterans Affairs and Chev did come up at the meeting that the Select Task Force had, and we will be working on sending a letter and meeting, hopefully with administration people, on better coordination. So I wanted you to have that piece of information.
Ma'am, I heard your voice Friday, and I appreciated that, and I think I brought up the point that the coordination is very well appreciated.
Senator Locke.
Madam Chair. Madam Chair,
yes.
I apologize for interrupting, but I had my button pressed since before Senator Searle did.
I am sorry, but guess what?
And I just
there
wanted
is
to...
nothing in queue. April and both looking at, there's not a thing on this board.
Thank you, Madam Chair. I just wanted to ask a question to make sure I understand it, because I heard April's report that this was repealing everything, so that maybe the audience can understand this as well as I can. But if you go to line 221 in the reenactment clause, I would ask staff to help me, because I don't understand what the language means that these folks who would avail themselves of this program are required to make satisfactory academic progress. And my questions are this. Does that mean you're required to make satisfactory academic progress to qualify for the program, number one? Do you have to make satisfactory academic progress every year to continue to get it, since you're already in a 2 or 4 year institution? Why would we give that determination to the university so it would be different, if I'm reading this right, at every university when you have to
We have an
make
answer for you.
satisfactory progress to get into college anyway? Those were my
Staff.
questions.
April.
Madam Chair, Senator Stewart, I'm going to take a stab at it, and then I may have to ask Wendy to further describe it. But what I would say to you, it's already required for other programs. Federal law is where it allows institutions to have that flexibility currently, and they have that flexibility under a number of other veterans benefits for the benefit of those individual students. So I would have to, if you want further in-depth questions, I'll have to defer to Wendy. But as you look at the language, you'll see it specifically references Title IV of the Federal Higher Education Act, which governs a number of those things. So it's no different than what governs the other programs.
So, Madam Chair, I think I understand what they were trying to do, but that's my concern in the bill, because it doesn't set that out. And the language is so loose that the University of Virginia could require a 3.0 to get into UVA, and I'm not saying that's what they do, but theoretically they could require you academically to have a 3.0, but they could require you to have a 4.0 to avail yourself of this program.
Madam Chair.
And it could be all over the board. That's the question I'm really asking.
Okay, I got 2 responses for you. Senator Gonzalez Hashmi, and then we're going to go to Wendy.
Thank you, Madam Chair, and I think our staff will be able to answer this. But this is, just to respond to Senator Stewart's question, satisfactory academic progress is standard in all colleges and universities with regard to federal financial aid as well as state financial aid. It's not an arbitrary decision that's outlined by individual universities. It has to do with the number of credit hours and satisfactory progress towards meeting the credit hours in a specific program. So if a student is taking a course, is majoring, let's say, in computer science, but is repeatedly failing one course, 1 time, 2 times, 3 times, federal financial aid, state financial aid is in jeopardy then. A student must maintain a minimum GPA requirement in order to continue to receive that aid. This is a standard process, and this prevents students from repeatedly taking courses and not meeting that academic progress requirement and failing out of college and university, basically. So it's not anything new, and it's not arbitrarily established. University of Virginia would not say satisfactory academic progress means maintaining a 4.0. It means maintaining a GPA that's above a D, and that's the basic definition, but I'm sure our staff can clarify it even further.
And Madam Chair, I don't want to beat the dead horse.
Senator Stewart.
But this is concerning to me because I understand what you're trying to do. You want to repeal all the things that cause the problems, but if this enactment clause is wrong, it could effectively gut it again. So my colleague here pulled up the federal student aid website, and it specifically says that this process to determine if a student is meeting all of his or her academic requirements could vary from school to school. And so that's what I'm concerned about. If we're going to put, that's what the federal website says. It says it could vary, and that's what I'm worried about. If there's a school that doesn't, I don't know why they doesn't want veterans' children in there, they could make a more difficult standard. But my question, I guess what troubles me about this is, if you've got to have a 2.0 to get into college and to stay in, why isn't that enough to keep your veterans waiver money? Why do we have to have a separate stand? Why are we giving them the ability to set a separate standard that varies across schools that you've also got to achieve when you have to have sufficient academic progress to get into school and to stay in. So why isn't that enough?
Wendy.
Madam Chair, Senator Stewart, the federal guidelines are more guidelines to allow institutions some flexibility in terms of how they put these policies, but they are required to have a policy. We did just look up UVA, and that minimum requirement is a 2.0 regarding that, and most institutions keep it at a 2.0. The reason that there's some discretion is they can determine how they apply an appeal process or put together an academic plan for that, but they have very strict requirements regarding how they apply satisfactory academic progress. One of the things that's mentioned is if a student is enrolled in an education program more than 2 academic years, the policy specifies that at the end of the second academic year, the student must have a GPA of at least a C or its equivalent. Again, there's opportunities for appeals for this as well, but it's more of they give these guidance at the federal level, and then the institutions are there to apply it.
Madam Chair, I got a question for staff.
Senator Serval, and then Senator Hoshby, you're still in queue, and then Senator Obenshain, Senator Locke.
Thanks.
In that order.
That's a question
Senator
for Wendy. I just really quick looked up satisfactory academic progress in the Code of Virginia and noted I think it's already referenced 4 different times. I think it's referenced for the governor's G3 program. I think it's referenced for the TAG grant program. I think it might be referenced for something else. Is this some brand new weird standard that the universities are just going to invent? Or I know you've said it's already a federal standard, but also in Virginia, is this a standard that we have existing programs we've used and applied in prior situations?
Madam Chair, Senator Serval, that's correct. It was mentioned in the chair's comments that this is an application that's applied to all of our state aid programs, and it's a requirement for, as you mentioned, the G3 program, the undergraduate financial aid, and for other student aid assistance programs.
Great. Thank you.
Thank you. Next in queue, Senator Obenshain.
Thank you. Appreciate the assist. I just try and put a finer point on Senator Stewart's question. My understanding is that in order to stay in school, you have to maintain satisfactory academic progress. And if that is the case, why do we have this language here? Why not just eliminate it?
Madam Chair.
Senator Hoshby.
If I could try to answer Senator Obenshain's question. Satisfactory academic progress is also very directly tied to the program of study that an individual student is a part of. So a student may be, let's say again, majoring in computer science and failing in those particular classes. That puts aid in jeopardy if you are receiving federal financial aid or state financial aid for your specific program of study. The guidelines are quite specific in the federal financial aid programs that you have to be taking courses in your program of study in order to continue receiving aid. So let's say I'm majoring in computer science, but I'm taking courses outside of my program. I'm not making progress in my program of study, and therefore I become disqualified from that particular course of financial aid.
So, Madam Chair.
Senator Obenshain.
And I appreciate that. But what we're talking about are children, 17, 18, 19-year-olds. And I can tell you that I'm a parent of 2 children who entered school thinking that they were going to study one thing and decided that that didn't suit. And some of these 17-year-olds, 18-year-olds, and 19-year-olds may find, by virtue of their inability to maintain satisfactory academic progress in their chosen field, that they really belong in a different field. And I wonder about the wisdom of cutting them off from access to this program because they got a D in computer science, but a B in an area in which they do show significant proficiency.
Madam Chair.
Chair.
I've got a line here in Q. I'm going to go to April, and then in my Q, I have Senator Locke and then for both.
Madam.
If you don't want to be heard, please let me know by pushing your button. April.
Madam Chair, Senator Obenshain, I would just add that's why federal law does allow for that additional flexibility for the institutions to consider individual circumstances. Correct. Madam Chair, Senator Obenshain, I would also argue that this is delayed by a year, and the administration will have plenty of time to weigh in on how the guidance will be regarding the implementation as well.
Thank you. Senator Locke and then Senator Bavola. And if there's anyone else who wants to be heard, please notify me so you can go in queue.
Madam Chair, I simply was going to emphasize what Senator Hashmi said with regard to institutions of higher education and what they do with regard to financial aid. And April indicated that there is flexibility allowed at the institutions, and it varies from institution to institution. It doesn't vary widely, but it does vary from institution to institution what they do with regard to this. And institutions have the ability to make decisions with regard to what they do at those institutions. It impacts athletics. It impacts what students' GPA can be if they want to belong to the SGA, if they want to join a sorority or fraternity. That's at the institution's discretion. But when we talk about academics, I think it is very important that institutions be able to make the determination of what it is going to do with regard to academic progress. Otherwise, students are going to be on the Forever a Student plan.
Madam Chair.
Thank you, Senator Favola, Senator McPike. And if you want to talk, push your button.
Thank you, Madam Chair. Having worked in various administrative positions in higher ed, I can tell you that universities make an investment in a student when they do accept a student. So it is definitely in the university's best interest to help every student succeed. And the student is usually assigned an advisor. Policies are made very clear to the student about academic expectations. But the bottom line is colleges and universities want the students they've admitted to graduate. They would like them to graduate within a reasonable time, 4 to 5 years, and they usually provide tutoring and other services that a student may need to succeed. So this reinforces, I guess, the comments made by Senator Locke. This is very much a common practice. This is not a new thing. Our colleges are very familiar with this. They are very familiar with the requirements that the state scholarship programs have and that the federal financial aid programs have. So I'm very comfortable with this. This is not a new concept, and this is not something that would be a burden to the students.
Thank you, Madam Chair. Thank you, Madam Chair. I guess there's a question maybe for staff. It's my understanding one of this code section, one of the issues we're dealing with today is also line of duty death for police and firemen. And it's my understanding and my recollection that line of duty death under the code section already requires the same thing. It already, in fact, requires satisfactory academic performance. Is that correct? That is correct. So, Madam Chair, hopefully that helps to connect something in the code that already deals with a host of folks that are here today, that this standard actually already applies to don't line of duty death benefit recipients in the Commonwealth. Thank you.
Thank you. In queue and in this order, Senator Deeds, Stewart, Servo,
Madam Chair,
and McDougal.
Madam Chair, I move that we report Senate Bill 6011.
Second. Oh, now we have a motion and a second that Senate Bill 6011 be reported. Senator McDougal.
Madam Chairman, before we get there, if my understanding what's on the docket today is your bill 6011 and Delegate Torian's bill that came over from the House.
That is correct.
Madam Chairman, I'd like to be very clear of what the specific differences between the two bills are.
I'm going to turn to staff for that, for your response. Staff will respond to your question.
Madam Chair, Madam Chair, do you want to defer to Delegate Sickles this year?
I'm here.
Chairman Sickles, I didn't see you sitting there. Could you please?
Thank you, Madam Chair. I'm just here to present.
Madam Chair, I'd ask Delegate Sickles, have you looked at Senate Bill 6011?
I have. I've read it online.
Okay.
I read it online, yeah. But I was just here to present 6003 at the appropriate time. But if
were you not here for my earlier comments?
I heard everything you said today, Madam Chair. And
okay, let me just reiterate. And taking up House Bill 6003, patroned by Chairman Torian, I expect that we will pass by both of those bills as they will be out of order.
Okay. Well, okay, thank you for clarifying that, Madam Chair. The senator asked what the difference were, and I was prepared to do that if you entertain his question. Otherwise, I'll just sit back down.
You still interested, Senator McDougal?
Yes, Madam Chairman, I'd love to know the difference.
Mr. Chairman, you may proceed.
Well, it doesn't have the two enactment clauses on the end. You've been discussing this number 7. And in number 8, we've already passed this morning requiring a JLARC study. I'm the current chair of JLARC. We met this morning. We put this study into motion. We're gonna have it done by the end of September. We're gonna study everything that you've been talking about up here. The questions that Senator Surville had, the one that you had about academic progress will be subject to everything that we look at in the report. If you pass HB 6003 today, we won't have to come back to Richmond to do a conference committee and put this bill in conference. I don't know the fate of the bill. If you were to pass it and pass it on the Senate floor, I don't know the fate of it in the House. We did pass the bill 92-0, and one of the advantages of passing HB 6003 is you won't have to come back again, and we can work on this thing all year, and we're here in January and do the right thing for the taxpayers of Virginia and for our students.
Thank you, Mr. Chairman. I'd like to turn now to Senator Surville to tell you the reason why we cannot take up 6003.
Madam Chair, I have a couple questions for staff. I don't know who's best to answer this, whether it's Tyler or Mike Tweedy or where's Tweedy? There he is over there. Mike, under the Constitution, there was a case called Gilmore v. Snidel, which is a case in the Supreme Court of Virginia in 1996, which I think talks about Article 4, Section 12. That section says that whenever we pass a law, we have to restate the entire budget item in the law before it can be a proper law. Is that right?
Madam Chair, Senator, yes, the Constitution requires that any section amended be published at length. And the difference between a normal code section versus the Appropriation Act is that the Appropriation Act doesn't have sections, it has items.
Right. Madam Chair, further question. Thank you. And so on, I think it's page 399 of the case, the Supreme Court of Virginia specifically looked at how that constitutional provision applies to a budget, and it found that when you delete an item and you add new language or delete language from an item, you have to restate the entire item in the law. Is that right?
Madam Chair, Senator Surville, that is my understanding, yes.
Okay. And further question, Madam Chair.
Senator Surville.
So the bill that passed out of the House of Delegates, and I believe it's also similar to Senator Reeves' bill, which purports to amend the part of the VMSDEP language in the budget that everybody's unhappy about. That language, as it's drafted in the bill, does not comply with that Supreme Court case. It does not restate the entire item of the budget like Senator Lucas's bill does and the one that's before us right now. Is that right?
Madam Chair, Senator Surville, correct. The bill amends only one paragraph of item 130, and typically, of course, the entire item would be listed in the bill.
Right. And Madam Chair, further question?
Senator Surville.
And because of the procedure resolution that was adopted for this special session we had, it had this very unusual language in it that prohibits us from making amendments to House bills when they come out of the House, go through the Senate, go over. So we're not allowed to amend the bill to fix it under the rules that the House of Delegates insisted on and that we agreed on for this special session. So there's no way to fix it. Is that right?
Madam Chair, Senator Serval, yes, that is my understanding as well.
Madam Chair, the final question from Mike.
Senator Serval.
So, Mike, is it correct that basically the only way that we can provide these people in this audience with any kind of relief that they're seeking, and that we do it today, is that we have to pass Senator Lucas's bill as the vehicle to get it out and on to the House and off to the governor's desk, or else we're going to have to be back here some other day and be messing around with this for who knows how long. Is that accurate?
Madam Chair, Senator Serval, yeah, that appears to be the case.
Okay, thank you, Madam Chair. And I don't have any further questions, but I think it's pretty clear from Mike's answers and at least my read of the Supreme Court case that the bill the House drafted is constitutionally defective. And even if we were to pass it, it would not be legal or proper for anybody to enroll the bill, even if the governor signed it, and it would be subject to constitutional challenge. I think the much safer course of action to preserve the benefits of these families is to pass Madam Chairman's bill and proceed with that as a course of action. If the governor feels like amending it, of course, that's something he can do, although it'd be nice if he didn't, and we could get this over with. Thank you.
Madam Chairman.
There's a motion on the floor, but Senator McDougal.
Madam Chairman, I guess I'm having a little difficulty because I'm just pulled up the bills to have them side by side. Of course, we've only seen 6001 for a couple hours now, but as I'm looking at Delegate Torian's bill and your bill, Madam Chairman, both of them restate Section 4-5.01 transactions with individuals, and both of them strike out list and strike out the language that starts with Section 7, waivers and related stipends, and both of them include everything through the end of what appears to be that section titled Birth-Related Neurological Injury Compensation Program. So, Madam Chairman, I heard Senator Serval's argument, but I'm trying to see what part of that section is not included in both bills.
I think you can get April to clarify that for you.
Madam Chair, Senator McDougal, it has to do with item 130, which I believe on Delegate Torian's bill starts on line number 14.
Madam Chairman, so I don't see item 130 in your bill.
Madam Chair, Senator McDougal, the way 6011 is drafted points back to appropriations in item 130, but does not set out item 130. I'm going to get Tyler to clarify.
So, Madam Chairman, under Senator Serval's argument, wouldn't that make your bill just as challenged?
No, let me tell you the reason why. I'm the chairman, and the chairman carries the bills. Tyler.
Madam Chair, Senator McDougal, if you look in item 470.10, lines 26 through 28, add a further condition relating to item 130, which is the item in Delegate Torian's bill that they're amending. And it says, notwithstanding item 130 or any other provision of this act, the appropriation in paragraph K of item 130 of this act shall be appropriated by the State Council of Higher Education to offset the impact of the programs under Title 23.1, Chapter 6 of the Code of Virginia. So that's the further condition for item 130.
Madam.
And we still have a motion on the floor and the three more people in queue. So, Senator Obenshain, Senator Stewart, if you're done? You still in queue? Because Senator, okay, all right, you out. Senator Obenshain, you in queue, and then it's Senator Reeves. Senator Stewart, are you still in queue?
Yes, ma'am.
Okay, Senator Stewart, Obenshain, and then Reeves.
Thank you, Madam Chair. Well, I was before you.
Well, you are after him in my queue. Senator Reeves is the last speaker.
I'm sorry.
Senator Stewart, you are now. You're up.
Me?
Yes.
Thank you, Madam Chair. Madam Chair, I have a two-part question, and I understand this is your bill, and I have respect for the chair of the committee and the person who carries the bill. And so I guess my question to you is, would you consider what I would call a friendly amendment to take your...
It's not allowed.
Excuse me?
It's not a proper motion.
Under the procedural resolution we adopted, there's no amendments are allowed.
Nope.
I thought that was just under the floor, on the floor.
No, that's a procedure resolution that was
Committee as
drafted
well?
for this special session.
Can I introduce another bill?
Would the chair consider introducing a bill, a different bill?
I've already introduced this bill.
That puts.
I've been working 7 days a week, almost 24 hours a day with this staff, trying to get to where we are now. So I think time is running out. We need to go in and dispense with this bill and move forward. Do we have a motion? But if Senator Obenshain still wishes to speak, and Senator Reeves, you're the last two speakers.
While I have great affection for our Finance Committee staff, I wonder whether the Attorney General's office has been consulted about this constitutional issue with respect to either the chair's bill or the chair of House Appropriations bill.
Who's going first? Dees or Serval?
And I have equal respect for
I think the
Senator
simple
Serval's
answer is
legal
no.
opinion.
No.
Now, staff, April.
Madam Chair, Senator Obenshain, we did speak with the governor's office, though, about it and how it would further restrict his executive prerogative going forward if it were to be adopted in such a way.
And he offered a legal opinion about the constitutionality.
Madam Chair, Senator Obenshain, the governor did not offer a legal opinion, but he may have since consulted the AG.
Thank you.
Yeah. And I'm probably out of order for saying this, and it took us 3 hours to get to where the governor said that to us, okay? This morning. Senator Reeves.
Thank you, Madam Chair. I just wish to speak to the bill, if I may. Madam Chair, I sit on the end of the dais, and I've listened to all the talk today, and I haven't heard any mention of the bill that I have, other than it's potentially unconstitutional. So because I heard that, I have a bill being drafted that's the same bill as myself and I guess Delegate Sickles' bill at one point, but it's being drafted to take out the part that I think the senator from Fairfax had mentioned might be unconstitutional that could be heard today if we wanted to stick around for it. But Madam Chair, my question, I guess, would be to the chair, don't we still have to waive the readings because your bill should have passed today? We'll still have to go through the same readings as the bill we petitioned and put before the chair during this committee hearing or during this day would still have to have that same 48-hour waiver. Is that correct, Madam Chair?
Senator Reeves, it has been the custom uses and practices that only the chair of Senate Finance carry appropriations bills.
I don't have an answer, Madam Chair. If that's the customs and practices,
I
I'm
thought
not
this
in
what I
charge.
remind you, that only I can carry an appropriations bill and not other members of the Senate.
Got a motion.
Got a motion on the floor.
Second.
There was a motion and a second that Senate Bill 6011 be reported. Madam Clerk, please call the roll.
Ayes 10, noes 5.
Ayes 10, noes 5. Senate Bill 6011 is reported. And as I indicated earlier on in the
Madam
meeting,
Chair, are you going to make the motion? Cree, you got it?
Senator Serval?
I had another motion on the other bill, Madam Chair.
Yes, Senator Serval?
Madam Chairman, I would ask that the other House bill on the docket, I think it was 6003, be passed by for the day.
There's a motion and a second. The House Bill 6003 be passed by indefinitely. Madam Clerk,
By for the day.
By for the day. Your motion was by for the day. By for the day. All in favor, please say aye. Aye. Senator Serval. The noes have been recorded. Is there a motion for Senate Bill 6009?
Madam President, I move that Senate Bill 6009 go out for the day.
Second. There's a motion and a second that my earlier bill, Senate Bill 6009, go by for the day. Voice vote. All in favor, please say aye. Aye. Nay, saying right? The noes have been recorded. No other business before Senate Finance Committee. The committee shall rise.
Senate of Virginia, Richmond, Virginia.